Hi everybody, this is Arkady Frekhtman. I'm a New York City personal injury trial attorney, and today we're looking at a verdict search of the most recent traumatic brain injury verdicts in the country. So let's get into it. The most recent verdict, according to Verdict Search, is on May 14th of 2025, and it's from Riverside, California. And it was a verdict involving a case that was decided in the Superior Court of Riverside County. And let's get into some of the details. So the incident happened on October 6th of 2021, where the plaintiff, his name is Mr. Garcia. He's a 54-year-old janitor at an elementary school in Riverside. He was exiting the parking lot of the school at a four-way intersection when his vehicle was broadsided by an SUV driven by the defendant. And so he claimed injuries to his head, neck, back, and he attributed it all to the collision. And he also argued that the plaintiff entered the intersection while the light turned green, while the defendant had to run a red light, thereby causing the crash. The defendant accepted liability but disputed damages. And the damages were a claim to have initially lost consciousness at the scene of the crash and that he was helped out of the vehicle by witnesses. The police arrived at the scene and there was no medical personnel that came, and the police did not file a traffic collision report. But immediately following the crash, the plaintiff was taken to a nearby medical clinic by a coworker, and later that evening, his wife took him to the emergency room where he reported suffering from really bad headaches and pain in his neck. And he claimed to have suffered a mild traumatic brain injury and herniated discs at C5, C6, and C6, C7. And he started treatment, Mr. Garcia started treatment with a chiropractor 7 days after the crash. He also underwent treatment with specialists in pain management and multiple orthopedic spine surgeons, neurologists, a neuropsychologist, and a behavioral therapist. And so after reporting ongoing pain, he ended up having a cervical fusion and lumbar discectomy. And more than 2.5 years later, he underwent a 2-level hybrid surgery, which included a 1-level fusion and a 2nd-level disc replacement. And this was at C5, C6, and C6, C7. And he claimed that all of the injuries were from this October 21 collision and that he would need future medical treatment for the rest of his life, including future spinal surgery. Both vehicles were totaled. The plaintiff's vehicle was impacted on the left side, but the only airbag that deployed was on the right side of the car. The defense counsel argued that Mr. Garcia may have merely suffered a concussion as a result of a mild traumatic brain injury, which resolved in a couple of weeks. That's a typical thing that they argue, like, you have a mild traumatic brain injury, it's just a concussion, it went away, everything goes away. And the defense further argued that Mr. Garcia had not required surgery in his neck, that he had received only 1 injection prior to having surgery, and that he had gaps in treatment with respect to his neck. And they argued that Mr. Garcia went back to work only a couple of weeks after the collision, suggesting that his injuries may not have been as debilitating as suggested, and also that Mr. Garcia suffered from degeneration prior to the collision, and that his pain may not be related. And they said he doesn't require any future medical care. So the jury found that the defendant's negligence had been a substantial factor in causing the plaintiff's harm and awarded damages in the amount of $8,569,756.35. And it broke down like this. Past medical costs were $429,000. Future medical costs were $2,317,000. Future pain and suffering was $5,037,000, and past pain and suffering was $786,000, for a total of $8.5 million. The offer was $1.3 million. It was a 9-day trial. The jury deliberated for 3.5 hours. The jury vote was 12-0 on all questions. Then the case after that is a case from Baltimore County in Maryland, and here it was April 10th of 2025. The plaintiff was a 55-year-old man. What happened here is that on June 23rd, 2021, the plaintiff, a computer engineer, was driving in Baltimore County. Another driver was making a right turn into an oncoming lane, and he turned too wide. And so the the plaintiff swerved left in an attempt to avoid a head-on collision, and the other driver struck the plaintiff's passenger side. And the plaintiff claimed brain, neck, and knee injuries. He claimed a traumatic brain injury of a concussion, which caused headaches, a vestibular balance disorder, cognitive dysfunction, anxiousness, and mild memory impairment. He further claimed aggravation of multiple degenerative cervical disc bulges and of a degenerative cervical disc protrusion, and he also claimed contusions of both knees. And at trial, his attorneys emphasized the brain injury. He underwent physical therapy for his claimed neck and knee injuries, and before the crash, he reportedly had migraines about once a month, but after, he suffered concussion-related headaches, which he said were in a different location than the migraines. He also had vestibular and cognitive therapy, and he treated with a neuropsychologist. And he was off work for some time, which he said was a result of the brain injury. And after he returned to work, he had trouble reaching the same high level of performance as before. He had to wear special glasses to prevent blue light and use special computer monitors, and it all aggravated his headache. So he sought $55,700 for past medical expenses and $223,000 for past lost wages, and an unspecified amount for past and future pain and suffering. And the defense denied that he had a concussion. They argued that he sustained a brief 6-week exacerbation of a pre-existing migraine disorder. They also denied that the collision aggravated any kind of pre-existing degenerative condition in the neck. And so the defense said just give an award of $40,000 to $45,000 for about 6 weeks of past medical expenses and past lost wages combined, plus $500 to $1,000 a week for about 6 weeks of pain and suffering. So the jury verdict was for $282,407. And it broke down like this. It was $53,632 for past medical costs, $223,775 for past lost earnings, and $5,000 for past and future pain and suffering, for a total of $282,000. I think in this case, what might have happened is that it doesn't sound like the brain injury was proven in the same way. Plus, it sounds like maybe it's a more conservative venue or more conservative jurors. I'm not sure. But something was going on with this case where it wasn't the same numbers like the previous case, 8 million, or the one in the middle was 92 million. This one was much lower. So yeah, something must have happened where it was more of a questionable case. You don't want any kind of questions. You want to be able to clearly show, the brain injury case. The next case was out of North Carolina, Wake County, and it was decided also April 10th. It was a verdict. And so here, it was a 32-year-old lady. She was a passenger in a car that was rear-ended, and she alleged a brain injury. And basically, her injury was a traumatic brain injury with a concussion, permanent post-concussion syndrome, which she said caused frequent debilitating migraines, light sensitivity, and blurry spots and floaters in one eye. A neurologist diagnosed her with a brain injury, but that was later. That was in 2024. The neurologist said that the brain injury was the source of the vision problems, whereas before they thought that she had a posterior vitreous detachment, but that was incorrect. And so she claimed migraines significantly affected her life. She sought $2.4 million for non-economic damages only, 2.498. So almost 2.5 million. The defense denied causation of the claimed injuries. The defense counsel noted that the impact was low speed. Neither vehicle sustained any visible damage. No police report was filed. The defense further pointed out that the plaintiff was not diagnosed with a concussion or post-concussion syndrome until more than 4 years after the crash. The defense counsel additionally presented testimony from a neurologist who gave the opinion that the plaintiff's medical history did not resemble that of someone who had suffered a concussion. And the plaintiff also had no objectively verifiable symptoms, the defense argued. The defense counsel suggested that if the jury believed the defendant's negligence injured the plaintiff, then it should award $15,000 to $20,000. And the jury determined that the defendant's negligence did injure the plaintiff, and the jury awarded $29,661.33. So yeah, a very low verdict, and actually I think under that law, because this was North Carolina, it was considered a defense verdict because the award was 1% of what the plaintiff had requested, and the verdict was also lower than the $50,000 offer of judgment that they gave in 2023. You know, they must have not believed the brain injury, or maybe they didn't like the fact that it was diagnosed 4 years later. And also, you know, I don't know how it was handled, who the experts were. It doesn't say here, so unfortunately, that's a low one. Here's a case out of California. Back in May of 2018, the plaintiff, a 52-year-old cable services and vehicle salesperson, brought his convertible roadster to a stop on Interstate 10 in El Monte when a sedan being driven by the defendant rear-ended him. So that's pretty straightforward, and we don't have to go into the details. They accepted liability. And then the damages were traumatic brain injury, cervical disc bulges, lumbar disc bulges, rotator cuff tear, meniscus tear of the right and left knee, and injuries to the hips. There was cognitive and behavioral changes, decline due to the crash. There were the injections, arthroscopic surgery for the rotator cuff tear, and meniscal surgery for the knee injuries. They also claimed that he would need a multi-million-dollar life care plan going forward. So he saw damages between $8 million and $8.3 million, which included $236,000 in medical bills, $177,000 in income loss, $246,000 in future medical bills. And so he claimed, yeah, $8 million. Now, the defendant disputed everything, and they said that the plaintiff was involved in 3 motor vehicle accidents, one of which was prior to this crash, and the other accident took place after this crash. And according to defense counsel, they argued that the plaintiff failed to meet his burden of proving which of the 3 accidents caused any of his injuries, and also said if the jury found that he had been injured in this crash, then the jury should return a verdict of like $47,000. So the jury returned a defense verdict after finding that the negligence was not a substantial factor in causing harm to the plaintiff. So yeah, maybe because he had 3 crashes, they couldn't really see which one caused any injuries. The demand was $5,250,000. The trial took 15 days. The jury deliberated for 115 minutes. The vote was 10-2. It was 7 men, 5 women. And the defense actually gets, in a post-trial, recoverable costs of $75,000. So yeah, that was a bad result, I guess. 0 defense verdict. You have to prove causation, and they didn't prove causation. So you could see, like, when people ask, like, what's a case worth, you could see, like, it runs the gamut, right? Some go for like 8 million, others go for 92 million, some go for 0, some go for 29,000, others go for 280,000. They're going to run the gamut. It depends on what you actually prove in court and how strong your case is. Let's do one more. Here's a case out of Los Angeles. This is a case from March 25th of 2025. And this is an accident that happened August 17th of 2022. The plaintiff was in his vehicle on State Route 14 in Los Angeles when his vehicle was rear-ended by another vehicle who was on duty as an employee of the California Department of Insurance. And they accepted liability. The damages were a spinal fusion. There was also a spinal cord stimulator, and there was volume loss in the brain's frontal lobe, and there was a diagnosis of traumatic brain injury. No longer could work long hours, think clearly, or even stand on his feet. The plaintiff also sought recovery for past and future medical costs. And the defense argued that the plaintiff had exaggerated his medical claims and that his injuries had resolved in the time between the crash and the trial. The jury found that the defendant's negligence was a substantial factor in causing the plaintiff's harm and awarded $32,868,692.93. And it was broken down as follows: $709,000 in past medical costs, $9,053,000 in future medical costs, $105,000 in past lost earnings, $1 million in future lost earnings, $18 million in future pain and suffering, $4 million in past pain and suffering, for a total of $32,868,000. So I hope this was helpful. Let us know what questions you have. We are here for you. Our goal is helping serious injury victims and families. All the best, everyone. Bye-bye.